Tuesday, she writes, "I think I had a psychotic break earlier. The whole ordeal was quite silly. I actually spoke with one of the voices in my head. Well, I didn't hear them until earlier today, but I only do then. My particular friend and I were practically screaming, bloodthirstily and ravenously. Thank God, physical confrontation was not, and I think it's fruitively, possible. I sound crazy."
That's straight from Carly Gregg's journal, read by Dr. Andrew Clark during the course of her case. So her defense now, after the conviction and, life in prison, making a motion for a new trial in front of the same judge who heard this case. They also have some complaints about the jury and the jurors' ages. Take a look at this one. I've never seen this one before. Carly was not tried by a jury of her peers. Carly was 15 years old when her trial commenced on September 16, 2024. Mississippi believes that only a person 21 or older possesses the maturity necessary to make decisions about the life of another. You've got to be 21, apparently, to serve on the jury down there. However, Mississippi also holds that a 14/15-year-old possesses the maturity necessary to make decisions about plea offers, understand the nature of the alleged offenses, comprehend the nature of the charges against them, effectively participate in their defense at trial. These two fundamentally opposing legal standards cannot be rectified. And, they've got a point, little common sense. You got to be 21 to be on a jury, but you could be 14 and tried by a jury. Let's bring back in our think tank Al Wunsch, Darnell Cross, and Jennifer Brandt. I don't think they're going to win, but it's an interesting argument, Jennifer.
It is an interesting argument, but I agree. I don't think they're going to win. I mean, she's old enough to be tried in this court. She allegedly committed an act that is, quite dangerous and quite adult, not something that a child would normally do. And I think she should be judged by her peers. These are her peers. These are other people in the community who are also being affected by this alleged crime. So I don't see her being judged by a bunch of 14-year-olds. I don't think that is going to happen. So I don't think she's going to win on that one. But I agree. It is an interesting argument. I just never heard it before, but I think it's a good one. It's one that they should throw in with the rest of them, but not a winner, I would say.
All right, they have another one regarding something. So this is regarding the testimony of Carly's therapist. Here's from the motion again. The testimony was of no importance in the facts in Carly's case and was elicited for the sole purpose of prejudicing the jury. This fact is highlighted by the state's erroneous belief that Mrs. Kirk, who was the therapist, was concerned about Carly reading this book as the title was underlined in her records without realizing that it was simply grammatically proper to underline the titles of novels. Let's take a look at how that went down.
The entire book, very difficult book, about a psychopath who lives in Russia, and he is poor. He is a student. He is very intelligent, and he comes on hard times, impoverished, and he has this obsession with this obsessive thinking of basically planning to murder a woman with a hatchet.
And Rebecca, in your note, you'd actually underlined the fact that she was reading that book.
Well, that was just for grammar, because you're supposed to underline a title of a book if you can't italicize it.
Okay.
All right, Al, it seemed the state was trying to make a big deal that the therapist was underlining the name of the book, Crime and Punishment, when, that's how you grammatically do it.
That's how you grammatically do it. That is a ridiculous point by the state with regards to this. I mean, first of all, the book Crime and Punishment is a 500-page book. It is not necessarily a very difficult book, but it's not necessarily geared towards a 14-year-old or a 15-year-old. It's a story of Raskolnikov, who is an impoverished student who ends up, murdering an old woman. Okay, and he's talking about everything that went on with regards to his intelligence, and he couldn't understand why he was, impoverished, and all these other people with less intelligence were doing better than him, and things along those lines. to say that that underlining meant that that was her concern is absolutely just ridiculous.
All right, so we'll give a point to the defense there. And if you need a copy of the book, I think it's on the second shelf behind Al. Now,
it's right over here.
Exactly.
Signed
by
Dostoevsky.
Exactly. Okay, let's get to one more of these reasons that they are making a motion for a new trial. It's about the testimony of Dr. Jason Pickett. Dr. Pickett's testimony regarding his undiagnosis of Kevin Gregg, that's the biological father, was improper, unethical, and highly prejudicial at trial. Pursuant to the ethical guidelines established by APA, the Goldwater Rule prohibits and enjoins psychiatrists from offering opinions about the mental health of someone they have not personally examined. Here's the testimony of Dr. Jason Pickett regarding Carly and her biological father.
To me, it made the diagnosis very skeptical of Mr. Gregg to have bipolar disorder. The very limited and sparse records from Dr. Hardy made it very questionable. My opinion is that, based on reading his report, that some of his opinion of diagnosing Carly with bipolar disorder was that he took Dr. Hardy's notes for face value. And when I read Dr. Hardy's records, importantly, he never said, Kevin has bipolar disorder and I reviewed the records from his recent hospitalization, or he has bipolar disorder because he met these criteria. He essentially just says he has bipolar disorder and he used to drink and maybe do a little bit of drugs, but he doesn't do any of that now. And so I really, only having 3 visits for 1 hour with no collateral records, minimizing his substance abuse and then prescribing him the controlled substances he did, I just wonder, did he have all the facts? And if he doesn't, Kevin doesn't legitimately have bipolar disorder, well then Carly, it's a lot less likely that she would.
Okay, Darnell, does the defense have a point here? And basically what they're saying is that this expert for the state did not examine Carly's father, so cannot come to a conclusion that he's not bipolar. And his conclusion that it's less likely that Carly is not bipolar because her father's not bipolar is unethical. I mean, it's a subtle thing, but is this a big deal?
It's heavy. It's a mounting thing, right? So you have to put everything before the court, and definitely before the appellate court. So they're basically saying he can't opine about this because he's not qualified, and the unethical word is huge. So it's unethical for him to do so. So therefore, the judge has to now take away everything he said and act like it didn't happen. And not that it didn't happen, but they have to conclude that that went improperly before the jury, and now it may have swayed the jury. So now we need to give this case to a jury that gets the proper information, ethical information, and that's what's happening. I think they're right on all fours with that. You have to put it in because it's a building, a little of this, a little of that, and then and then hopefully you get the new trial.
We shall see. Great job as always, Al Wunsch, Darnell Crossland, Jennifer Brandt. Great to see you. When we come back, I will reveal